privilege is progress in itself. So thanks very much. 2 months ago, on the 5th of April of this year, I was in federal court in San Jose, California, arguing against the dismissal of the Muhammad case, which the professor just mentioned. This is a case on behalf of 5 victims of the CIA's rendition program who were flown to countries like Egypt and Morocco or to CIA black site prisons in Afghanistan and elsewhere where they were tortured. Not surprisingly, the CIA, represented by the Department of Justice, came into court to demand the dismissal of this case, submitting and citing an affidavit from CIA Director General Hayden, who said that any litigation of these claims, any confirmation of these claims, any discussion of the interrogation methods that may or may not have been used against our clients would cause grave harm to national security. Well, here in Washington on that same day, on February 5th, General Hayden was testifying to Congress, and in that testimony he revealed that 3 other CIA detainees had in fact been waterboarded, a highly secret interrogation method, far more secret and grave than any of the allegations in our complaint. 2 months before that, General Hayden had written in a letter to CIA employees that the CIA had decided to destroy videotapes that documented some of those interrogations because in the CIA's view, those tapes were not relevant to any ongoing congressional or judicial investigation or inquiry. And to me it seems that together these episodes pretty conclusively demonstrate that the government's notion of secrecy when it comes to these issues is a lot more malleable than it would like to admit. If information or evidence is needed to hold the government liable in a civil case, or to prevent a possible future prosecution of government agents, the evidence is withheld or possibly destroyed. If, however, that same information or evidence might be useful politically to the administration, or might be needed in order to prosecute or execute enemy combatants in the government's custody, that same evidence can be revealed without any harm to national security. I could come up with literally dozens of examples of contrasts like those where the exact same evidence was released or withheld depending on whether it was in the government's interest to release it or to withhold it. I think it's an important frame for our discussion today because so much of the debate, as Aziz alluded to, revolves around this notion of judicial competence, whether judges have the institutional expertise to protect national security, to determine the import of evidence. But there's very little discussion of what I think is a much more serious problem, and that is the structural conflict of interest when you have the executive branch, which is itself being accused of wrongdoing, submitting affidavits demanding the dismissal of cases on national security grounds. And I will say a little bit more about that in the 5 to 7 minutes that I have. I want to make one more broad point before briefly discussing some of the issues that have arisen in the litigation. And this sometimes raises eyebrows, but it's important to start this discussion. Every single case that has been brought by the ACLU, by the Brennan Center, by others, by the Center for Constitutional Rights, since 9/11 that has tried to hold U.S. officials accountable for torture, every single one of those cases has been dismissed at the very outset, not on the merits, not because the courts held that torture is legal, not because the court said that the factual allegations were not proven, not because the court said that these facts don't constitute torture. Every one of them was dismissed on what a non-lawyer might call a technicality. State secrets has been at the heart of those dismissals, not the only reason, but a very critical reason why these cases have not ever proceeded beyond the initial complaint stage of the litigation. In other litigation that Aziz mentioned, the litigation against the National Security Administration for the so-called terrorist surveillance program, the government's invocation of the state secrets privilege works something like this. The government said, unless you as a plaintiff can demonstrate to the court that you yourself were a target of NSA surveillance, you have no standing to bring this claim to the court. But the state secrets privilege prevents you from ever learning whether you yourself were a target of this surveillance, and therefore no one can bring this claim to the court. Why am I raising this point to frame the discussion? Because of another canard that you hear a lot in the state secrets debate, and that is that, unfortunately, regrettably, we're so sorry about this, but there are times when the interests of individual litigants must be subordinated to the interests of the public and to the greater good. Well, that formula might work in a tort case like Reynolds. It might, where you really have a few individuals trying to get monetary damages, and there might well be a legitimate national security interest that supersedes that. But I would argue that it's quite different in a torture case. than it is in a tort case, or in a case like the NSA surveillance cases. There's a significant public interest in ensuring that executive actions comply with our laws, with our Constitution, with congressional mandates. There's a significant public interest in preserving a judiciary as the final arbiter of whether the other branches of government have acted within the law, so that you don't have a scenario where the public interests are on one side and the private interests are on the other. At best, there are public interests on both sides, and I would argue that in our cases, the public interest is overwhelmingly on the side of the plaintiffs and not the government.